Here is a story that appears not going away. A federal judge ordering the State Department to conduct new searches. They say get back to it and find emails that the former Secretary of State Hillary Clinton might have sent and received about Benghazi. Ned Ryan, former speechwriter for President George W. Bush, has been looking into this and want to bring Ned in to talk about it. Good morning to you.
Morning,
Bill.
Now,
where is this coming from now, this judge?
Well, so a little bit of backstory. A few weeks ago, the State Department informed people that because there was not as much public outcry, they didn't feel a sense of urgency in going and looking for more Hillary Clinton emails. Obviously, Judicial Watch, ACLJ have been on this and been requesting from both FBI and the State Department the emails that they had requested through the FOIA process. We've now discovered in this case with the State Department, Bill, that the State Department didn't even search its own servers, the state.gov servers, for the emails of Hillary's top aides, Huma Abedin, Cheryl Mills, Jake Sullivan, in regards to emails pertaining to Benghazi. And so Judge Mehta, who, by the way, is an Obama appointee, said the State Department has an obligation to go search its own servers for any emails of Hillary's top aides that pertain to Benghazi.
Clearly, this judge was not satisfied with the evidence or the information that came back. The judge, by the way, Amit Mehta, you mentioned an Obama appointee, said the following in part on screen. If Secretary Clinton sent an email about Benghazi to Abedin, Mills, or Sullivan at his or her state.gov email address, or if one of them sent an email to Secretary Clinton using his or her state.gov account, then State's server presumably would have captured and stored such an email. Exactly. Therefore, State has an obligation to search its own server for responsive records. Basically, the judge is saying, get back at it.
You didn't do what you were supposed to do the first time. You're going to go back and you're going to do this correctly. You have an obligation. I thought the thing that was interesting, Bill, the justice's lawyers tried to argue that this would set a bad precedent to go search the aides' emails, that it would belabor the FOIA process. Oh, I'm sorry. I'm sorry that government employees who are on the taxpayer's dime would be belabored by this. And she wasn't buying that argument. She said, you will go back because Hillary Clinton's emails are a unique situation, unlikely to be replicated in the future. So she essentially told the Justice Department, the lawyers that were making this argument on behalf of State, they will go back, you will look at the state.gov servers, and you will do your job that you didn't do previously. So, again, the arguments coming out of the State Department have been, well, there hasn't been a sense of urgency, nobody's that interested, all of these arguments, and the judge, again, an Obama appointee, is buying none of them.
Sorry to interrupt, but does it change now? Is it different now because there's a different administration and there's a different boss at the State Department with Rex Tillerson?
Well, there is a little bit, but again, some of this delay is happening because there are still holdovers from the Obama administration who, quite frankly, do not feel a sense of urgency, do not feel that they should be pushing this in a timely fashion. And so, Bill, this kind of addresses one of the other issues that we're dealing with right now in this transition from one administration to another. There are still holdovers in many of the departments from the Obama administration. They are not on the Trump team. They are not on, working on behalf of the Trump administration, and they're doing their best to delay these things.
What would Tillerson do about that?
Well, my hope is, and I know coming from the Oval Office, President Trump has made it clear to the various departments that they are to be working on these things, these requests, in a prompt and timely fashion. There has been a delay. There's been pushback. It has not been made a priority. I have to tell you a little bit, Bill, I'm finally encouraged by Jeff Sessions willing to go and really get aggressive on some of these other things. But this is something, these emails and getting to the bottom of these things, whether it's Loretta Lynch's and James Comey's manipulation of the email investigation. You know, the FBI earlier this week, the ACLJ said the FBI lied to them about saying certain emails didn't exist. So I hope that in the various departments, again, under the Trump administration, people will realize this is an absolute priority that we get to the bottom of this, because, Bill,
let me go back to what the judge said here. A central premise of the ruling is that the State Department servers archived emails from Clinton's top aides, those that I just mentioned. However, it's not clear that happened regularly or reliably. And you have to ask yourself why, and I think what it comes back to, Ned, ultimately, it's trust in government. It's trust in Washington on behalf of the American people.
I want to make this last point, if I could, Bill. Either the law is the law, or it's not. And if the law is king, again, one of our founding principles, it is not arbitrary. It applies to all people. It is to be done in a timely fashion. if people don't think that the law and our government and our institutions are to be trusted, everything becomes arbitrary. People begin to lose trust in their institutions, and it has serious implications on society. So we've got to be serious about this. And again, I would remind people and state the obvious. This government works on behalf of the American people who fund every last dime of our government and the employees who work for it.
Well, it looks like they're going to get back at it. Ned, thank you. Ned Ryan, we'll see where it goes
Bill.
in Washington. Thank you.